Definitely welcome everybody. This is Shelley Colvin. I'm with the League of Women Voters of St. Louis Park. This is the League of Women Voters of the Metro uh, area that we're putting on our spring meeting, our spring program. And we've got John, is it Boehler, John?
Healer.
Bueller. Okay, Bueller. Um, and he is the policy counsel at the uh, ACLU of Minnesota. Prior to his work with them, he worked for the Minnesota House of Representatives for 4 years. He's originally from New Jersey, graduate of Bucknell University and Rutgers School of Law. You live in Minneapolis, and you've got your partner and two kids. Any pets?
Not anymore. Just the two kids.
Okay, okay.
With
John,
function similarly.
yeah, and we've got Deb Price, I want to say as well. She's going to be monitoring questions, that kind of thing. So it's a kind of the two of us and you, and we're all three hosts. And John, I wanted that to be so that you could control your screen, your side deck, all that kind of thing. So we made you a full host. So,
Um,
John,
Let me see if I can get there. Can everyone see what I'm looking at on the PowerPoint?
Yes.
Yes. Okay.
fantastic.
So this, what we're kind of working with is a presentation that the ACLU provided to the House Judiciary Committee last month. That will be I'll be updating as I go. But this is the general outline of kind of how we've been talking about the issues in the state. We've had an opportunity to present. I did to the state Senate and to the state House, and our executive director did to various congressional panels. One in Congress and one field hearing was held in St. Paul in January. And so we've kind of been building off of this presentation. Um, so we start, as we all know, this November, December, the announcement of Metro Surge, 3,000 federal agents. That's 2,000 from ICE, which is Immigration and Customs Enforcement, and 1,000 from CBP, which is Customs and Border Protection or Patrol. I mix those two up. We get 3,000 federal agents here, ostensibly as a supplemental fraud investigation. And that I say ostensibly because we didn't really see any fraud related investigations or arrests, but that was the stated goal. An ICE director at the time called it the largest immigration ever. What that spirals into is what we've seen and what we've lived over these last few months, which are thousands of Minnesotans harassed, detained, intimidated, assaulted, tracked, and two Minnesotans killed in extrajudicial killings, and another who died in custody, I believe, down in Texas. That's Victor Manuel Diaz. And so this is where we're starting to get to the out of date information. Is that the ACLU, as of this February, had received 700 reports of constitutional violations. We're well over 1,000 at this point. The Attorney General, who started his portal after we did, is also over 1,000. And the way we like to talk about these 700,000 plus violations is that they're kind of the end of the funnel. If you think of how these are the ones that we hear about that are described to us in detail, but that doesn't include that requires individuals to know of their constitutional rights, know that the ACLU of Minnesota is collecting these, know that the portal exists, know or feel comfortable or safe reporting this. And in a lot of the instances that we've seen in greater Minnesota, they need to have somebody available to make this report on their behalf. A lot of our reports come from the cities and then also the suburbs because there were a lot more people. There's the density of the area and the propensity of volunteers to be able to step outside, see what's happening, and make a report.
So we have that increase, that significant increase in reports in constitutional violations. we're well over 1,000 habeas petitions filed in Minnesota since the start of Metro Surge, and that's compared to less than 100 in the previous 12 months. And the standard for habeas is quite high. So it's the fact that they are both being filed and being granted at the rate they are is something that we have never seen before. And in the past 6 months, judges around the country have totaled over 4,400 different illegal detentions made by ICE. And so that's kind of where we are. And then we jump into the lawsuits that the ACLU has filed, and similarly positioned organizations. We talk about constitutional violations in the state. We're talking about violations that we documented in the last few months of the First, Second, Fourth, Fifth, Sixth, and 10th Amendments to the Constitution. So when you think of those constitutional protections, thinking of the Bill of Rights, 10 amendments, the first 10 amendments, 6 of them pretty clearly violated, and numerous times. And so that is, as we talk about, Tincher v. Nome is our First Amendment observer and protester lawsuit. The named plaintiff in that is Susan Tincher, who was observing. She was sitting in a church parking lot in South Minneapolis when she was detained. She was taken to the Whipple building. Her clothes were taken. They cut her wedding ring off. They held her for several hours. And then they released her with no charges and no explanation, and certainly no apology. That also includes other observers, protesters, journalists who were, pepper sprayed, tear gassed, detained. And we had an injunction granted in that. The Eighth Circuit stepped in and overturned it. The underlying case is proceeding, and we have pretty strong evidence. We have over 115 declarations at that point of violations of the First Amendment right. And this is broader than simply just retaliating against protesters or observers. It also includes those threats to retaliate against protesters or observers. So we've seen this documented both in the cities and pretty heavily in the suburbs, where ICE or CBP will show up to people's vehicles and threaten them with arrest or threaten them with detention. And that threat to violate those First Amendment rights is itself a constitutional violation because it has a chilling effect on people exercising those rights. So you don't need to be detained for observing ICE to have your rights violated. If they say, we will arrest you if you continue to follow, that is a violation because they're trying to get you to stop exercising the rights that you enjoy. The other case that we filed is Hussein v. Nome. These were all filed when Kristi Noem was still the secretary for the Department of Homeland Security. So I'm actually not sure what the procedure will be for updating the caption, but that's where they are now. This is a Fourth Amendment case. This is about racial profiling. Our named plaintiff in this one, Mubashir Hussein, is a 20-year-old citizen who was taken outside of his place of work. The officers wouldn't look at his work authorizations or his citizenship papers. They wouldn't listen to his boss, who tried to present his citizenship papers. They drove him around for about an hour. Finally did look at his papers, ran his name through the system, determined he was a citizen, and just left him on the side of the road. Again, just a 20-year-old who was just, I think he was stepping outside of his place of work to get lunch or a coffee, something like that. This was argued a few weeks ago, and the decision came down. Our request for a preliminary injunction was denied because the federal government has attested that Metro Surge is winding down. So the request was denied, but the underlying decision, the facts that the court found, their opinion, their writing on it, it was basically one of the best losing decisions we've ever received. We didn't get what we'd asked for, but the court found that all 23 people who's either plaintiffs or declarants to the case were stopped without probable cause. That the only basis for their stops were race or ethnicity, and that the government's proffered arguments for why they stopped these individuals didn't hold up to any scrutiny and didn't really make any sense. So when we say that there has been widespread racial profiling, widespread detention or arrests or stops made on the basis of race, these are Fourth Amendment violations. The government likes to rely on Justice Kavanaugh's concurrence in Vasquez-Perdomo, but it's not a final decision. It's not binding, nor do we think that like a full court, if they really considered the issue, would consider the types of stops we're seeing to pass constitutional muster, to be valid under the Fourth Amendment. We don't think a stop based on race or ethnicity that would just involve a quick license check would be constitutional. We certainly don't believe a multi-hour or a transfer to Texas, some sort of detention like that, would withstand constitutional scrutiny either. But the court has, we've got an early decision that there was racial profiling, but what the court said here was where there's no convincing evidence that with Metro search ending that these particular plaintiffs are going to see that harm come in the future, which is one of the major standards for preliminary injunctions. There are other cases proceeding. The state of Minnesota, along with the cities of Minneapolis and St. Paul, has sued for violations of their state and local sovereignty. Fridley Public School District, this is an Education Minnesota case. They're suing for violation of the Administrative Procedures Act. This is surrounding the decision. This was about a 20-year-long policy from DHS, started under George W. Bush, carried through Obama, Trump 1, and Biden, to not do immigration enforcement at sensitive locations. This was revoked by the Trump administration on day one of the second term. And we've kind of seen the results of that. We've seen, ICE at churches, ICE at daycares, ICE at schools, ICE in colleges, ICE in courtrooms, all of these places, ICE in hospitals, ICE in healthcare facilities, all of these places where they used to not go. And one of the prior DHS officials, there was a quote, not prior to Trump revoking this policy, but in support of the policy, that basically noted that DHS can meet its enforcement mission without denying people access to their places of worship or to food or shelter or to children to education. And they understood that the violent nature of these immigration detentions and takings should not be occurring in places, of this heightened sensitivity where children and families are present. And we do have state level work that we're trying to do a state level reinstatement of this policy. But it's much easier when it comes from the federal government. The Advocates for Human Rights also filed a case about access to counsel at Whipple. They had a very good success as a first, fourth, and sixth amendment violations here. Their injunction was granted. I'm not sure if it's still in place because it was a few weeks ago and I know they were revisiting it. But this stopped a lot of the policies that ICE and CBP were using to deny people the right to counsel at Whipple. These are things like not giving them private spaces, not allowing them to make phone calls, trying to transfer them to Texas before they had an opportunity to contact counsel or contact their family to try to retain counsel. And so what the court did in this case was kind of step in and said, you can't transfer them for 72 hours. You've got to give them a phone call within the first hour. You've got to provide them access to their rights, both in writing and in audio form for people who can't read or can't process it that way. And you have to do it in languages, English, Spanish, Somali, Hmong, French, and I think there might have been a few others in there. And then also, if you are going to transfer them, you need to give them an opportunity to consult with their counsel beforehand to file any motions that they may do. And part of that is because things like habeas relief, which is release from custody, is an area specific relief. So if you are held here in Minnesota, you're filing in the District of Minnesota in the 8th Circuit. If you're held in Texas, you're filing in Texas and in the 5th Circuit. And the 5th Circuit has a much higher standard for habeas relief and immigration, which is actually something that they determined while Operation Metro Surge was going on. They restricted that access to habeas relief. So we really wanted to ensure, and the Advocates for Human Rights did a great job of ensuring that Minnesotans who were taken had their cases heard in Minnesota, or at least an opportunity to. A quick run through of the amendments that we talked about being violated. The First Amendment, Hinsher and Hussein. There were some threats to journalists. The News Guild Communication Workers of America joined as a plaintiff on that case. The Second Amendment, these were based on statements after the killing of Alex Preddy about when and where you can't bring guns to. And he was a licensed concealed carry holder. You are allowed to exercise your Second Amendment rights in conjunction with your First Amendment rights. You can be subjected to more scrutiny. If you're at a protest and you are the one carrying the gun, the police can provide you with more scrutiny, but you are allowed to do that. Across the political spectrum, we have seen people bring guns to protests and not suffer the response that Alex unfortunately suffered. But those kind of threats of you can only bring guns to protests that we approve of is a constitutional violation. Similarly, in the Fourth Amendment, those are our cases like Hussein, where people were based on, or, stopped racially profiled. Fifth Amendment cases, again, this is where we get to the a little bit of the out-of-date information. The chief judge for the District Court of Minnesota, Federal District Court of Minnesota, Judge Schultz, found that 96 orders had been violated. He was accused of falsifying, lying, I'm not exactly sure how to phrase it, by the U.S. Attorney, U.S. Attorney Rosen, the Trump appointee. So Judge Schultz went back and reviewed those orders and found that it was actually over 200 at this point. And so when he found those 96 court orders just in January, just in Minnesota, he said that it was likely that DHS or ICE had violated more court orders in 1 month in one state than most agencies have violated in their entire history. And now we're well over double that amount. And so for most of these cases, these are habeas relief cases where the judge is saying, give them either a bond hearing, let them pay a bond and get released, or release them by a certain date. And then they're not, DHS or ICE is not doing that. They're not giving them the hearing, or they're not releasing them. And so each of these cases, each of these court violations results in people spending more time either in Whipple or in Texas in these crowded detention facilities than they should be. So there are real on-the-ground impacts to each of these court violations. The Sixth Amendment case, that's the one we talked about with the Advocates for Human Rights. The quote that I like to pull out of that is one of the DHS attorney, one ICE agent telling an attorney, if we let you see your clients, we would have to let all the attorneys see their clients, and imagine the chaos. And this is what the courts really called out the court for, or called out, this is what the courts called out ICE for, which is saying you sent a ton of agents here to make a ton of arrests, and you did not plan for the administrative aspects of dealing with that. There's no staff here processing people, making sure that they're in safe conditions, making sure their families know where they are, making sure their attorneys know where they are, making sure they're getting prompt court hearings. You just send a bunch of people with guns and handcuffs and zip ties, and you've made mass arrests, and because you've overburdened the system by your own accord, you don't get to use that as a defense for violating constitutional rights on that. And then the 10th Amendment case that's also proceeding. And so we get into some of that. These failed prosecutions. And so in Minneapolis, we heard about the attempt on the life of DHS officers who were attacked with a shovel, who may have had a gun drawn on them. They shot a Venezuelan immigrant in the leg. And eventually those prosecutions were dropped because the ICE agents were making untruthful statements. And the statements had been so untruthful that they were actually under internal investigation, which is the only ICE officers that we know of that are under internal investigation based on their conduct here in Minnesota. Similarly, in Virginia, up in northern Minnesota, agents accused a man of trying to ram them with their car, but did not choose to present any witnesses or any evidence to that. So those cases were dismissed. Similarly, when confronted with video from bystanders, another Minneapolis case fell apart when they accused a man of tackling officers. So what we've seen is just a constant falling apart of these cases. In Chicago and around the country, 0 convictions. Chicago, LA, Minneapolis, Louisville, DC, Memphis, all these places that have had ICE searches, they have 0 convictions for assaults on the ICE officers. And that is, for people unfamiliar with how the federal judiciary works, or the federal U.S. Attorney's Office, they have over a 99% success rate when they bring charges, and that's in previous years. So to go 0 for 6, as they've done in Los Angeles, is almost mathematically impossible given their prior history, unless they've started excessively charging people, which they have been. And that's led to pretty significant criticism from the federal judiciary. The Judge Schultz quote that I mentioned earlier, Nancy Brazel, another judge in our federal courts, that's kind of what I was talking on, where the Constitution does not permit the government to arrest thousands of individuals and then say, we've arrested too many people, we can't guarantee them their constitutional rights of due process, of hearings before the court, of meeting with their attorneys. And then some quotes from around the country, from what judges have seen in Texas and in the Texas detention facilities, of what the West Virginia judge has seen in terms of detentions and things like that. And we've seen that kind of expanding into other areas. It's not just protesters, it's not just observers. When Senator Mark Kelly from Arizona, and other federal elected officials mentioned that you're allowed to disregard unconstitutional orders, they faced prosecution. ICE agents who have left the agency have testified that all of the constitutional trainings have been cut or eliminated. When somebody criticized DHS by email, they opened an investigation to him, sought via administrative subpoena, basically access to all of his travel and communication records over previous years, including his credit card spending, driver's license, social security numbers. And then he was eventually visited by law enforcement. And that was a mid-60s retiree from Oklahoma who emailed the office, emailed an attorney at DHS saying that he expected more decency out of the administration. And that resulted in an investigation. Where this leaves us in Minnesota is dramatically short-staffed at the DOJ. We are down to a few dozen prosecutors. They've flown in DOJ attorneys from out of state. They've started using military officers. There is actually a case pending before the court seeking to have those military officers barred from doing criminal prosecutions as violations of the Posse Comitatus Act, which prevents the military being used for domestic law enforcement. So we'll see how that goes. But what we've lost here is, particularly for an investigation that started as a supplemental fraud investigation, is that we've lost the chief attorneys of the Civil Division, Violent Major Crimes, Fraud, and Public Corruption. All 4 attorneys who were staffing the Feeding Our Future case have left the agency. And when senior prosecutors leave the agencies, what they do is they have to evaluate their caseload. They say, okay, you had 40 cases. Which ones can we assign to new people? Which ones can we no longer afford to prosecute? And the way the administration has prioritized it is they are focused on the immigration cases. They are not dropping the immigration cases. So instead, they're dropping these violent criminal charges that the DOJ was pursuing, including trafficking fentanyl, trafficking cocaine, trafficking methamphetamine. The first man on that list had 12 prior convictions. The judge said that he could not be released under any bail conditions because he was both too violent and too much of a threat to flee. So when his attorney left the office, the DOJ just decided no longer to pursue those charges and released him back into the community. And we are the ACLU. We believe this individual was entitled to all of the due process that the Constitution guarantees of an attorney, of a jury trial, and to the sentencing that it matches the crime if he was convicted of it. But if we're even an organization like ours that is wants to ensure that everyone is not held guilty in the court of public opinion before a jury finds that to be so, would like to see maybe these cases prioritized over, the deportations of children and gardeners and daycare workers. But that's kind of where our DOJ is at this point. They're severely understaffed, they're overworked, and it's causing them to make errors, and those errors are having real harm for people who remain in detention. And so that's what we have on the that's the presentation we used to give. There have been more cases filed. Operation Paris, which was a attempt to revoke the refugee status for Somali Americans, has been stopped. There's another federal case seeking to prevent DHS from revoking their temporary protected status. This kind of parallels the case that Massachusetts, I believe, recently got an injunction preventing the rescission of TPS for Haitian immigrants and Haitian refugees. So we're optimistic there. Operation Paris has been stopped. It has been enjoined at this point, but there will be appeals there. And the federal government doesn't really take their losses well. So what they've done in that case is they've pivoted to the immigration court, and they've just started scheduling people who were generally a few years out from further hearings. They've started scheduling them all immediately to try to speed up that administrative process. So there are cases there. There's a clergy case that has been filed about the failures at Whipple to provide access to clergy, and I believe it's an interfaith coalition of Christian, Muslim, and Jewish leaders or religious leaders who have filed that, who were denied access to Whipple to minister to their congregations. There's more litigation ongoing. There's more litigation contemplated. I think we have a couple hundred attorneys that have been trained to do volunteer habeas cases, we've been really proud of the community stepping up in that way. Habeas is usually an ACLU priority, but when you go from needing to file a select few a year to a couple thousand in a month, it just strains capacity. And so we've seen a lot of support from the private bar in that circumstance. And, for people who've never done habeas before or never appeared in federal court, they've been winning at a pretty high clip, which is both evidence of the government's overreach, but also evidence of how hard they've been working and how well they've taken to it. So that's where we are on the legal side, the litigation side. I work in the policy realm, so I spend most of my days at the Capitol as well when I'm not helping support the legal team, trying to push legislation in this area. And so a lot of what we've been working on is pushing things that work in response to what we've seen here, and also some long-term problems. And so what the ACLU has been focused on for years, that ICE and CBP's presence have exacerbated, are the surveillance and the incarceration conditions. And the surveillance abuses are ones that we've been concerned about, but didn't really, it's always hard to gain a lot of public traction until you experience what the surveillance state being weaponized really looks like. And so we've seen abuses from the federal government using license plate readers, using facial recognition technology, using data brokers, which is, these data brokers, and some of them are large and some of them are local, like our Thomson Reuters here, is they'll just scrape all of the public information that exists on people on the internet. That is name, age, height, weight, hair color, eye color, known associates, which is usually family members, workplace addresses, things like that, and they'll sell that information. Ostensibly, they do it for background checks, but the federal government also buys it to try to locate people. So data, license plates, facial recognition, geolocation searches is another one. So your devices like your phones, your AirTags, your GPS in your car. They can get what they call reverse warrants, or a geofence, which is you just kind of draw a digital net around a map, and you just record every device that's been in that area. And then you associate that device with its owner. And so these have been used for a long time, both locally and federally, mostly for criminal investigations. And that's what they're intended to be used for. If a crime occurs and you don't have any witnesses, they try to look for who was in the area when the time occurred. What the federal government has instead decided to do is particularly just geofence, who was at the protest when and who was at this location during that time. Sometimes it's protests, but sometimes it's just, a march to downtown Minneapolis or a memorial. And a lot of what we have in the federal government's case is just this black box of information. So we don't really know when they've run these searches. We don't really know what they've done with that information. We don't know if there's a list. We have seen some level of retaliation with people having their clear and their global entry and their pre-check canceled. The government they're calling revoking security clearances because people photographed or documented ICE. Which is, again, also a constitutional violation and is being pursued. But it's that sort of weaponization that we've been trying to focus on. And again, we can't at the state level control what the government does, but so much of that information funnels up from our local governments and from our state government, and trying to either stymie or limit the flow of that information to, is there a criminal investigation ongoing? Is there a warrant? Is there a subpoena? Why are you looking for it, instead of just this open network? particularly in like our license plate readers. We have a bill up on Tuesday. Representative Tabke from Shakopee. I'm not sure how far the West Metro League of Women Voters extends, but Representative Tabke from Shakopee is bringing a bill to limit license plate readers. And some of our suburbs, one suburb had 180 searches run against their cameras in a month. It's kind of a lot. One of our suburbs had 425,000 searches run against them last month. And so that's as far away as, Florida, Los Angeles, Texas. It's people looking through our license plate reader data to see ostensibly if there's a criminal investigation, although there is evidence that they were using it for less legal purposes as well. And these have been abused in other states, both for immigration violations. Texas found there was one in Texas that was used to try to locate a woman who had an abortion out of state. And there have been like individualized personal abuses too of law enforcement officers using these to track ex-girlfriends or ex-wives or things like that. So there's a lot of potential for abuse in these systems that we're trying to work back on. We are trying to reinstate some of that state level protected spaces, and we have various litigation being carried. It's moving pretty well in the Senate with bipartisan support on most of the pieces, and has not moved in the House due to the tied nature of the House. So we're cautiously optimistic that we will get something through in the Senate and then see what the House decides to do with that. I'm not holding my breath, but public pressure is an important thing, and that's what we are encouraging people to do in that realm, is to push for some sort of response, because it's hard to believe that after the experience of the last few months that no response would be necessary. So while we're arguing for a broader and more expansive and harsher response, we do think no response is not necessarily what Minnesotans are asking for. And then there are a few other smaller pieces to ensure that our immigrant communities are protected. One of those pieces would be like Plyler v. Doe is the case that requires states to provide to provide education regardless of immigration status. And that was a 5-4 decision from the 70s. So I use this in all contexts, but it's very similar. The right for an immigrant child to a public education is as safe as the right to an abortion was under Roe, 5 or 6 years ago, which is to say it's one Supreme Court decision away from being revoked. So we are trying to put in a state level guarantee of that, which is something we can certainly do. That has moved forward as well in the Senate, but not in the House. But that's sort of that forward-looking immigration protection. The law as passed would do nothing at this point because it just supplements that federal constitutional guarantee. But should that federal constitutional guarantee fall away, and there are people actively working to pull it away, we want to make sure that our state is ready, and that our state, and that our schools have certainty. That they're both going to continue to educate immigrant children, that they're going to continue to get the state funding to educate those children, and to avoid that kind of two-tiered class of citizenship that would be created if you ended up with immigration distinction or educational distinctions based on immigration status. And I think I think there were like 60 to 80 anti-ICE or ICE response bills that were introduced. We're not working all of them, but some of them were in like the state tax realm. Some of them were in rental assistance type areas or small business assistance. These are not like ACLU areas, but there are people working on those issues as well. And again, with 101 legislators in one party and 100 in the other, and various members running for higher office, there's a lot of competing goals out of this session that we think will make it hard for a larger response to get passed. And I think that's pretty much everything I have. I know I just kind of like fire hose talked at everybody for about 40 minutes straight. So,
well, John, you talked about the federal prosecutors being overburdened. Um, how about ACLU? I mean, I don't know how you're normally staffed, but have you been able to up your a lawyer?
We have really relied heavily on our volunteer and supplemental basis. So those cases like Tincture or Hussein that we've talked about, we are working with private counsel on it. I don't have the names offhand.
Right,
And similarly, like with the habeas cases, we have put we've put a lot of that on the private counsel. We are staffing up and we are trying to, but it is it's been probably the busiest time. I started like 4 or 5 months ago, so it is the busiest time my coworkers say they have seen. But I also have, we've been busy.
yeah, I bet you have. Um, I know in St. Louis Park, the mutual aid organizations, the signal groups, they're very, very active, and they still are. What was amazing is that when they said that all these ICE were going to be withdrawn or whatever, and I know that they always have a certain number in the state for the that have been here doing prosecutions as they normally would, not as in this type of way, but
Right.
some of the facial recognition, the ICE following protesters or those involved in the signal groups, um, being able to call them by name, follow them to their house, all that kind of thing. Can you say anything to that? Because that has been just wow.
Yeah, and so that's part of that First Amendment case. Sorry, Dorothy, I'm gonna pull that down, but if you want me to put it back up in a bit, I can do so. As part of that First Amendment tincture case, that we have some plaintiffs who were followed home or led home or threatened, and that it gets to particularly here in Minnesota, like we've seen state level reps followed home. Seen state senators who were staked outside their home, and for those state reps and those state senators, like the experience, the assassinations of the Hortmans and the attempted assassinations of the Hoffmans, like that was 9 months ago. That lives almost 9 months ago today, I think, and that lives still in their head, and that's the threat, right? These unidentified, unaccountable, masked, armed men show up to your house and just say, hey, Shelly, nice house you have here. Like it's a mafia movie, is what it feels like. It's a shame if something would happen to it. Shame if something would happen to you. Like the implied threat is pretty obvious. The federal government has said they don't mean anything by it, but I don't think a single court has bought that explanation. Um, and so we've been working on that. Similarly with that, you touched on the warrants piece a little bit there. It's it's hard to explain how absurd it sounds. That it is. Administrative warrants did not exist when the Bill of Rights was written. They didn't exist really until the 1950s, and they essentially just say that if you detain somebody, ICE is allowed to detain somebody when they find them out in public without having to go to court. That was how they were used for roughly the past 70 years. And then by internal memo last year, I said, no. Administrative warrants function like judicial warrants, and you can access private property. They didn't publicize that. They didn't tell anybody about it. And that's not really how you redefine key terms in the Constitution. Like warrant means something. And one of the things that the founders were so worried about was that overbroad use of the warrant and the lack of a neutral reviewer of that warrant. Is that in the way these administrative warrants function is that either an immigration judge who is an employee of the executive branch, they're hireable and fireable, unlike other federal judges, or ICE agents themselves are just writing themselves a warrant. So you sit there and they just fill out a form and says, "I'm allowed in your house," and then they come in. That's not what was contemplated, and it's exactly what the exact opposite almost of what the founders were trying to protect against. And so there is probably litigation coming down the pipe on that from some angle. Again, I don't really sit on all the legal team meetings, so I'm not sure if that'll be another group, us, but or some national organization, but it is like you just cannot fundamentally reinterpret the Constitution by executive memo. That's just not how it works. It can't work like that in any constitutional system.
I have some questions if you want to remove the PowerPoint.
Oh, is it still showing?
Yeah.
Yeah.
Oh, sorry, I thought I took that down. Okay.
Okay. Let's see. First one is, what is the status of administrative orders issued by ICE?
Yes, and I think that's kind of to Kathy's point. I think that's kind of what I was getting at in
Okay.
that last point. Is that ICE is still behaving as if they are functionally the functional equivalent of a judicial warrant, and that is not. That's again not how anybody else believes it, nor is it how other courts have interpreted it. So I do anticipate some litigation to come down the pipe on that one.
There's two more. Is there anything cities should be doing?
Varying things that we have asked cities to do. There's a lot of voluntary immigration data that cities collect that we don't believe is necessary. These have been smeared as separate, these separation ordinances have been smeared as sanctuary ordinances. I like the word sanctuary. It is. I like the historical context of a sanctuary. Growing up in a religious household, a sanctuary was something you aimed for, or you sought out. But not sharing that voluntary data with ICE and CBP is one. Making sure that their cities restrict that access to license plate readers and data sharing is another. We're trying to avoid suggestions of confrontation with the federal government, trying to put local PD and ICE at odds, but at the same time there's a lot of cooperation in them that we don't think they should be doing. And at the city and county level, what ICE has been doing is they've been trying to deputize local officers through what they call a 287G program, and we have a proposal at the state to ban it. But it is essentially just allows all local police officers and sheriff's deputies to behave as ICE officers, and they've gone from roughly 100 of those around the country to about 1,100 in just the past year. And that's the promise of a lot of future funding. It's the promise of training, and it's the promise of kind of constitutional immunity because they do operate with that same federal immunity. But what the local governments do not get is they do not enjoy that federal immunity. So we've seen around the country, and one of the reasons we're pushing to ban it, both because it's morally outrageous, but also like New York City just got hit with $92 million. Suffolk County in New York, $112 million. Bristol County in Massachusetts, $800,000. Nobles County here in Minnesota about 4 years ago, $200,000. Like these are significant judgments. So the officers enjoy that federal immunity, but the local governments do not. So any constitutional violations that they commit acting in conjunction with ICE here, those local governments are going to be on the hook for. And all of those cases stemmed from pre-Trump ICE violations. So you can only imagine what this new ICE is going to look like and what headaches that's going to cause for local governments in terms of litigation and settlement costs. And so we have been pushing people. These are optional. The federal government can't force you into them. So there are about 7 or 8 of them operational. None, I think, in the metro, but places like Mille Lacs, Freeborn, Sherburne, the city of Isle up in Mille Lacs County. They all have these agreements, and we've been pushing. We've been working with local organizers to try to get them to withdraw. Both, again, because we think the conduct is not something that the local agents should be participating in. It ruins that public trust that they work really hard to create. The prosecutors hate these because it's hard to get witnesses to come forward or crime victims to testify if they have immigration status questions or their family members do. And then they're also just going to be a major financial hit for these localities. So those are kind of the few areas that we're pushing on. But we've been mostly focused at the state as opposed to the locals right now.
Thank you. I have 2 more questions.
Mm-hmm.
Shelley, can I go ahead or do you want to?
Go ahead. I had one. We've only got a few minutes left, but looking toward which would affect immigrants that non-citizens are voting, and we know they're not, and they're looking at immigrants as these non-citizens. And in August and in November, the intimidation at polls and whatnot. And we also have a couple of questions we don't want to necessarily go over particularly, but I wanted to say that was something that the league was concerned about in our, which is yeah.
We, along with a lot of our national partners, are looking at it and looking at the proposals. And we've been in contact, along with others, with Secretary Simon's office. It's something that their office is very concerned about. One area that I've been pushing a lot of people in as a forward-thinking look is what we created in 2023 when I was working at the legislature, were these permanent absentee lists. You just register online, and every election they send you a ballot as like an absentee ballot. You fill it out, you send it back. You are never putting yourself in the polling place. And I love going to polling places, and I will be going to the polling places, but I'm not at risk of racial profiling in detention. And so for people that are concerned about that, but do want to ensure they vote, we've been really trying to direct people to these permanent absentee lists. And those absentee ballots can either be dropped off or mailed back in if you're, concerned about timing or USPS or something like that. But that's what we've been directing people to. And then there are national planning around polling place protections. I mean, we do have state laws involved, prohibiting that kind of activity at polling places. Nobody is allowed there unless they're a voter or election worker, and that includes federal officers, local law enforcement, peace officers. Licensed peace officers are only allowed in to vote or to quell a disturbance when called by the election judge. So we have laws protecting these on place. What we don't know is, will local law enforcement step in and try to ask ICE to leave? That is, and so we kind of have to contingency plan around that, and are trying to.
Well, thank you, Deb. I think we're almost there, but why don't you catch another question?
Okay, I'm going to go with Pat Levy. There were reports of agents taking pictures of captives and posting them online. Has there been any prosecution of this despicable behavior?
I don't believe there has been any yet. I know the Hennepin County Attorney's Office is investigating. I don't know, the timeline for that will be long. So in instances, when I talk to people like the League of Women Voters, a lot of whom may be attending the Hennepin County Convention, Mary Moriarty is open to these investigations, but Mary Moriarty is not going to be the Hennepin County Attorney next year. So will those Hennepin County Attorney candidates continue these investigations is a good question. And I don't know. I haven't spoken to any of them. I haven't heard from them. But we know there will be turnover in that office. I'm not sure if the Attorney General is doing that. That is usually a county level issue because of the criminal nature. But there's a longer timeline for those prosecutions, a longer timeline than the Trump administration certainly has. So we do hope for investigations in that realm. And I can, to Karen's question, which I think is the final one on ACLU doing conditions on detention centers. We did not have time to file one when Whipple was still as heavy as it was. But there are national groups. There are groups with with area specific lawsuits, either ongoing or planned, mostly for like the Texas and Louisiana based detention centers. But there are also groups looking nationally for kind of a national result, saying, that Alligator Alcatraz and Whipple Building and Dilley down in Texas, it's, we've created our own sort of Gulag Archipelago type situation around the country, and it needs to be dismantled. And so we have been directing people with Whipple related or other detention facility related complaints kind of to those national organizations. So I'm not sure if it was a practical question or just a general information, but if there are people that suffered through those detention conditions either in Texas or here, we can help connect them with the attorneys who are building those cases.
Does anybody, Deb, John, are there any other questions that we can quickly, we're down to just a couple minutes, but want to hit?
No questions have been added. So,
Okay. Well, John, this has been wonderful. I'm so glad that you were able to join us. Thank you. Thank you for all the work that the ACLU does. Really, really appreciate it. Um, yeah.
No, thank you for having me, and thanks for everybody to turn out on a Saturday morning. Um, though I guess it's better than salting or preparing to shovel. So.